as we take the session forward. First of all, there was some meeting ID issue, but the way things keep on, people have logged in. And as they say, that it's better to try and fail rather than failing to try. And amongst us, we have Justice K. Kannan, a former judge from Punjab and Haryana High Court. And those who have been connected with Beyond Law CLC know it very well that it was when we were on the baby footsteps, Justice Kannan took us forward with his insights, and thereafter, with the God's grace, Beyond Law CLC has been taking sessions on different perspectives. And the knowledge which Justice K. Kannan has, he has written a lot of books, coupled with he can take every subject with such an ease that you are sometimes awed with that fact. He can take sessions on our platform on reservation. He has taken on motor accidents claim tribunal matters, that is motor accident claims, then mediation, and so on. And once we were connecting with him, then he said that he's revisiting the forensic evidence. And therefore, when we made a request to him, as usual, he was agreed, because to share knowledge has always been his forte. And we remember when we were appearing before him, the amount of cases he used to dispose, that was also amazing, and people were awestruck. Without taking much time, since we are already 10 minutes late from the scheduled this thing, I will ask Sir to take things forward, and we are allowing you the screen sharing as desired by you. Right, sir?
Yeah, thanks, because it has been almost some 8-9 months before I connected to you actively, and I'm so happy to be back. It really amazes me that you should be able to persist with such regular features of video streaming, and you have followers, your persons watching what you are giving to them with such enthusiasm. That shows a lot about your sincerity of purpose and the lawyer's own interest to know more. I literally resisted the temptation to be addressing, because I thought there had been a little too many and they must all be available. And like in a judgment of the Supreme Court, they said, you leave indelible footprints. If it's in the digital world, it's never forgotten. It's there to ever remain. So therefore, anyone will be at liberty to get back whatever subject they want, they'll be able to see. But I made an exception because I felt like coming back to Chandigarh. It had been such a long time. So this lockdown keeping us in our own respective homes. When I get homesick, it was Chandigarh, homesickness meant Chennai. If I'm in Chennai, if I'm homesick, I only think of Chandigarh. So I thought this would be an occasion to connect again to persons who I known so well, persons who I truly like very much, and the court that has truly given me a wonderful experience during all my tenure there, however short it was. The subject of what I'm going to be talking is that which I was working on recently for the 27th edition. So therefore, I just thought I will take you through some of the features which struck me. And in about 45 minutes or so, I thought I'll fill you in with the matter that I gathered and which I've tried to put inside. To have a beginning as to what we understand forensic medicine or forensic science. Forensic is derived from the word forensis. It's a Latin word. It means a forum. In Rome, forum is the meeting place where the civil and legal matters were discussed by those with public responsibility. It refers to the application of science for the purpose of resolving legal disputes. It has many fields within it operating. One will be DNA profiling, toxicology, ballistics, drug analysis, fingerprints, serology, digital forensics. All these matters which lead to detection of crimes and criminals is what we are seeing when we are looking at forensic science. Historically, many of these disciplines, they developed either as forensic application of laboratory-based scientific methods, while some of them were developed as part of investigative processes by the police. Now, I've made a reference to the topic as forensic science and the new perspectives. I said I'm working on that, and therefore I will take you through some of those aspects which I thought are very relevant and which have come through. In the analysis and the new perspective, I got two perspectives from two principal sources. I'll share with you what they are. I suppose I'll be able to share the screen. Yeah, that should be possible. One is, yeah, there you have. I'm sure you're able to see that. It was one of is the report to the president, the forensic science and criminal codes, the president of the United States. It is in the year 2017. 16 was prepared. Then they formally was there. It was presented at the time Obama was there. The idea was ensuring scientific validity of feature comparison methods. This was sent to the executive office of the president, and this was sent by the President's Council of Advisors on Science and Technology. I think they have a beautiful method, a system in place where the scientific methods are brought and given before people. The idea is that the courts are the carriers or the dispensers of justice. They should be properly advised by the scientific community in order that they apply the right tools to give. Yet another subject, which yet another aspect which I wanted you to see is this. This also I'll present immediately quickly of what I have in mind. The other book, another source was this. I suppose you're able to see. This is forensic DNA analysis, a primer for courts. Look at that. It's a kind of a, you must have heard about the primer for school students. It is literally a primer for courts, for the courts. Who has produced it? This has been produced by the Royal Society. This also I'll just run you through because I want you to have the first taste of what is there directly, and we'll see who has presented it will be a matter of some interest for us. I'll just show to you if you're able to see. That is Sir Venki Ramakrishnan. Sir Venki Ramakrishnan is the Nobel laureate, is knighted by the Queen, and he is the president of the Royal Society, and he has presented this to the courts. The idea is all the law courts in UK will have the benefit of this report, a primer of what should be acceptable, what is the scientific basis for understanding some of the important subjects of what we are going to be talking about. So therefore, you have these two this happened in the year 2017, 2018. They give you very fresh perspectives. In the way I would like to address, I would first like to tell you about something which is most certain that it will be relied on in any criminal investigation these days. Wherever there is a sexual offense, or where the presence of a person, whether it was there or not, the identity of the person, paternity, these are the issues. This is DNA evidence. DNA evidence, therefore, is something which is talked about more and more often than ever before. At a very fundamental level, I'm sure you know. I'll just give you how it would look. This again, perhaps all of you know, but I can't just resist the temptation to let you see what I'm going to be doing, what I'm going to be talking about, and therefore some bit of science. I'm sure this again you're able to see when we are talking about DNA evidence. We are talking about cutting the minutest cells in the body, and it's available in all body fluids. All you have therefore saliva, tear, sweat, semen, all these carry the DNA. The aspect about DNA is it's 99.9% is the same for everyone. It is that 0.01% which is different. That's what is the individual. So when we talk about the individual characteristic of the DNA, we are talking about that 0.01% which is different from others, which brings real certainty to it. Now, what is it that these two reports, the PCAST, the advisors to the president in USA and the Royal Society, or what is with Venkatraman giving a report to the Royal Society, in turn to the courts, and the courts which take it as primer, they have new perspectives to understanding DNA evidence. Just to have this in your background memory, you just see there is a yellow thing. You'll find a kind of a helix of what they say. There are two strands, and then they run in opposite directions. They're connected by pairs of what they call as bases. Bases is AT. You don't need to think adenine and thymine. There could be, this is A and T. You'll find each one of this kind of a ladder. It's a kind of a swirled ladder. Another is G and C, which is guanine, and another is cytosine. So these are the things which are bound. And how is it done? This is stuck to a sugar phosphate backbone. This is the basis on which, if you go through an analysis, this is what you ultimately get. You just have this in your back of mind. I'm not going to be troubling you with too much of science, don't worry. But when we're talking about forensic science, what is the basis? What concepts we're talking about? What is new about it is what I would want you to know. There are what we do in forensic investigation. You try and see if there is some person, if there is a DNA which you need to be picking up, it will be taken from the victim. If there is a sexual offense, or what is there, her DNA will be taken if it's against a woman, or if there is a child, because sexual offenses, mostly we are concerned and worried about the crimes against women and children. And therefore, children, it's gender neutral. When we talk about women, we are talking about obviously female sex. So, and that, what is stuck there? What is there, if there is blood, or if a person has smoked a cigarette or something, that saliva, all these things leave the DNA. So therefore, the document, this becomes very important. And the American president, the recommendation they said, among other things, the topic, when they said forensic science in criminal court, they said the most important factor is gathering these details which are characteristic. And in the manner of gathering these details, what are all the problems which can take place? What will be the scientific method by doing it? They said, when a DNA profile is obtained from one person, the interpretation of that DNA profile is normally straightforward. When you're talking about just one, of one person to another, one person, is he the person who did that? And take his DNA, take that lady's, and find out from whatever could have transmitted from one to another, semen analysis or anything. Or if there was a person was using, say, a condom or something, and he had left there at the place, he will be literally leaving a visiting card. There is nothing else which is necessary. It will be such a sure proof of getting at that person, that he was the person who had come and what was picked up from the scene. You will be seeing it immediately in a situation of what is the evidence which was collected there at the spot. Whose DNA do we see? Is there a suspect? That suspect, is that person's DNA? If that is merely an issue of 1 + 1, there is no difficulty at all. It can provide, this DNA can provide exclusionary evidence. It can say this person was not. You can very easily identify from what you are able to pick up that this person was not. But then the problem could be situations where you don't have, supposing the person had used a condom where nothing is left there, of someone not available there. There is no part of the body where she has, but he has left behind cigarette or something, cigarette stub or something. It may be possible to gather DNA from there. But there could be so many factors which can come in the way of our inability to gather the best detail. That would be on account of contamination, and there could be errors that can occur in the DNA analysis process. The scientists can address specific issues through the processes, checks and control samples, which are all associated. Now, this is in situations where there are mixed, where there are several complex and mixed DNA profiles. These days they use computer software, and there are a range of software programs which are available, which can bring to a precision of the differences, the vital differences. The same data derived from the complex and mixed DNA profiles will be analyzed repetitively, because one full genome runs to about 3 meters in length, that can be composed in a human body. That is taken from out of that. You take a small piece, and I said about 99.9 is the same for everyone. It is the 0.01 we are seeing as different. And again, these things, they go for mutation. There could be additions and deletions. So therefore, they could be similar for two persons. It can be misleading. So you need to make short tandem repeats, STR as they say it. They'll make repeats to see within, because this 4, or I showed to you the 4 things which get connected. They will repeat within a short span, about 15, 16 is an adequate data. Repeats they will take 16 to 25 is what is taken. And if they're able to see a similarity within that, then it is the DNA of that person is surely taken. Now, I was telling you this DNA as to how it is taken, how it is collected. There is some interesting feature about that as well, and that will be with reference to what is the kind of thing which you do, what is the process which is undertaken, and what is it that anyone does, how is it taken first. You will know when we are talking about DNA profiling, we are talking about adoption of several techniques are possible. Each one of them, they are targeted different parts of DNA. Some such as STR profiling, I said now, that is the short tandem repeats of what I said. It is the most common feature of a DNA profiling. So when in any case of what you're representing, if somebody talks about DNA profiling, we see what is the technique which is adopted will be the first question which you will ask. And then it is normally this STR profiling is what is taken for comparisons to short terms. And there could be some other method in situations where there is a sexual offense, where there is only a male and a female. Through the chromosomes, chromosome have XX is female, XY is male. So therefore, if any part in the chromosomal analysis of DNA, if you find Y, then it means there is a man semen which has come, and therefore that connection, that Y can be easily identified with the person who we suspect. Or if there is no specifically suspicious person, there could be a national data which is available there amongst the suspected persons, or persons who have been already convicted, or persons who are taken to prison. I will have surely something on that as well. This will be targeted. What they will do is to target the nuclear DNA in the chromosomes, and then get how to take it. I'll just show to you a small feature about that in a minute for you. That is to have an idea about how small we are talking about. Where is it picked up? How is that immediately identified? I'll show to you now in a minute. We'll just have a look at that as well. This is through. Just a minute. Allow me to give you the show to you. I'll present it again for you. Yeah. Yeah. Look at this. I hope you're able to see. Look at that. This is, I'm talking about where you take it. What is the method which you're adopting to gather the DNA? I'm giving you some background and then coming to legal issues of what surrounds this. This is a cell. I'm taking the cursor around that. This is the cell. The cell, the body cells of what we have, we leave it in so many places. The skin, you
just press
close the door.
class. So could you just press the R class so that only the picture will come into being? Now the entire export PDF, etc. is showing on the screen. There's an image of the R class. Just press on that.
Yeah, let art. Where do I see? I'm trying to figure out where I make it to go bigger.
It should be on the edit, because I've seen that on the top.
Yeah, here. Which will go to expand this. I'm trying to figure out where. Maybe I've lost it. Or have I lost it?
I also just forgot, because it's an image of an hourglass where you click it.
Yeah, there I have. Fine. Yeah, I have. There I have.
It's fine. It's fine.
Yeah. No, it's better.
It's fine. It's better.
Fine.
It's better.
Now you see there is a cell. Oh, I'm taking the cursor around. The cell, out of that, that's a nucleus. Within the cell, there is a nucleus. This nucleus, if you look at the chromosomal value of how you're taking it, if it's X and Y, these chromosomes are already showed to you a helix. This is how it is. This goes like that. That is one method of extraction and a method. Another one, within the same thing in this cell, you have the mitochondria. This is when you, within that this is the mitochondrial DNA. You take it out of this, from each one of them, they are taken. I'm now showing to you within the blue portion. This is again, from there, from this, it's also taken. So these are various methods which you take, depending on what you want to prove, depending on what is going to be established in a particular case, you will adopt the technique. And that is what is done in order that, therefore, you find there is the issue of somebody else who is involved. We know this is the person who is involved. Then we need to adopt that particular technology. Just a short while ago, some 1 or 2 years back in Supreme Court, the issue was one Ravi versus the state of Maharashtra. The Supreme Court was referring to that. When you're reading a judgment like that, you must know what is it that they're talking about. The Supreme Court's passage says something like this. It was a case of a 2-year-old child that was raped. And what was the analysis which was necessary? It was contended there that YSTR analysis shown was not reliable. The Supreme Court was rejecting Y analysis. What is it that we are saying? In the chromosome, X and Y, it can be there only for a male. X and X is for a female. It was a 2-year-old female child. They were trying to get at a particular analysis. I told you, a chromosomal analysis of DNA will yield immediate result to identify a particular Y chromosome, which ought to be there only on a male. Then you will be able to analyze the whole of that DNA to see. Through repeats, you'll be able to find whether that is the person. So while saying that, the court said, in cases of, this was in the judgment in Ravi, they said in cases of sexual assault, DNA of the victim of the perpetrator are often mixed. Obviously, there is a kind of a complex of two DNAs of two persons. They get mixed there. And the traditional DNA analysis techniques like autosomal STR will not be possible. And YSTR method is the unique method which will isolate the male DNA by comparing the Y chromosome, which is found only in males. So this is what they were saying. So when the Supreme Court makes an analysis like this, in the kind of a sexual offense where we are seeing, what is the method of DNA which they should adopt, which will give the best and optimal results, is what the court was seeing. And they said, this is what will be done. When they also referred to a kind of an STR where you hear also words like loci and things. What happens is when you have, like I said, a genome is a 3 meter long. We are taking a small sample out of all that. When you're taking a small sample, and then go for repeats. What is done is they see that there is a serious degradation, could be due to extraordinary heat, poor sampling, gathering was not possible easily. The best of it was scraped and taken, and the conditions of storage were not appropriate. In that situation where the minimal traces are available, they say that the best method will be through the short-term repeats of what will be done, the autosomal STR, where they said in several cases they have found to identify a small unit and then go for research within that is what will give important results. Now, however, the point was what kind of report must be given, because there is a serious chance of a degeneration of DNA. What do you do? What are all the places from where it is to be done? The laboratory examination of the submitted item to locate any body which is present. That will be the first thing which will be taken. Recovery and sampling of body fluid. Evaluation, these are the processes. Evaluation of the collected sample, whether it is properly kept. This is it possible to extract the best? And the DNA extraction will be the next one. Then to also see how much DNA is present within the extracted sample. That's the quantification. How much worthwhile you can take out of that. And then after doing that, the extraction, they will copy it. They will know it's amplifying as what they call it, of the SDR regions, many times using a chemical process. What is the chemical process? We don't need to be worried about. There is a polymerase chain reaction. They call that PCR. And they will separate the PCR products by size, and they will then go for data interpretation. This is what happens as a typical situation. There was a case now in UK of a 21-year-old sex worker. She was stabbed to death, and 3 local persons were picked up. The suspects were picked up, and they were all imprisoned. And then after a long time, when the case was going on, and this conviction was also rendered, these 3 persons, they were all said to have joined and did that. They collected some evidence, and what was because they had some suspicion that this DNA match. Here again, there was a report given by a scientist saying this DNA of this person in the next DNA, there was a match. The case was reopened. This is the curious part of it. And they said DNA which they ran through a national database, and they found it matched with a 14-year-old boy who at the time of the offense was 2 years old. This was a big surprise. A 2-year child could not have done anything to this sex worker. The child could not have, this is impossible. Now, this 2-year-old person, they were immediately looking for the members of his family. What are all the DNA for the person, of other persons? They found is the boy's uncle, one Jeffrey. It provided a complete, when his DNA was taken, it provided a complete match. So he later confessed, and they found a conviction as possible. Now, there is an assumption that DNA provides a 100% match. But in reality, what we must know, that is the fresh perspective which PCAS now says, it is probabilistic. You must, any scientist must say, when you are interpreting something, when you're talking about the complex DNAs where there is mixed fluids, there are bound to be the separation and getting the particular person. Where you're going in a wild search, you're not able to identify a particular person. There can be false negatives. It may seem same, but you may be committing a mistake, because if there is not a proper analysis, or where the repeats are not adequate, you may end up gathering the very same DNA which anyone else may have. I told you already, 99.9 is the same for everyone. It is that 0.01 which is different. And you'll have to be looking for that distinct aspects which will show out that individual. So now there was, if any report is ultimately made, and PCAS said that to the Supreme Court, and that's what again Venki Ramakrishnan gives it as a primer to the courts, that whenever there is a complex mixture, if there is a scientist who affirms something, don't merely go with it. Look for the scientific validity. They said there are three things which you have to do in every situation where whether a person has given the report correctly. Our assumption is that scientists will do, you would have done the correct thing. And you have also under section 293, many of the scientific reports in CRPC, they say if the report is given, forensic expert report is given, that evidence is not even necessary. So therefore, you have several situations where a report is given, the report is available. The person who carries out the actual scientific analysis is not even brought to court, and the report is given to the court. Court says, now this report is filed, taken on, exhibited as a prosecution document 10, 11, 12 or something like that, and no evidence is necessary, then they would say this report says this, and therefore we find it is the same DNA. That is that's a very dangerous thing, because scientific analysis matters even in DNA. What was the nature of sample which was taken, the purity of the sample, what is the statistical probability, what was the technique which you had adopted, can it assure a purity of the sample which can reveal exact results. All these are important, and a doctor is bound, or a person, a scientist who has worked on that and then gives a report, must qualify that report and say how this has been prepared. Without it, it's completely waste. No purpose will be served. And therefore, PCAST said, and the same thing is what you find elsewhere in the British primer as well, there needs to be a foundational validity. Now, what do we understand by the foundational validity? I said there was a new perspective about the scientific research. They said whether a technique which you have adopted to extract and then carry out the analysis, whether it can give absolute and correct results. That should be the first one. Then whether the same would be obtained if the technique is repeated. If I do it now, tomorrow if I were to do, it should give me the same result. That should be the second thing. Therefore, repetitive in character it should be. Whether the same result will be obtained if someone else performed the same thing. So therefore, it has to again be not dependent on a particular person preparing it. Anyone else doing it must also secure the same result. Therefore, the first prerequisite is there should be a foundational validity. The second one ought to be the validity as applied. Any analysis into validity as applied, it requires an analysis into whether the forensic examiner is capable of reliably applying the techniques, because these are all things which we need to be worried about, because these are all assumed. These are the scientists I know. As a cross-examiner, I don't understand any of the science matters. And if you had to say, I didn't like science in my school and therefore I took the law, you are mistaken. Now there is so much of science now, because we already know, even in digital issues of recording digital evidence of what is possible, the computer applications, and so many things of what are happening there. You again saw some of the judgments about the cryptocurrency, this box chains, all these which talk about new technologies have so much of science there, and therefore it is essential that we truly prime ourselves to follow a bit of science and understand what each one of these matters. So the validity, application of the validity must be dependent on whether the examiner has reliably applied the technique in the particular way and accurately represented the result. So in the report, in fact, PCAST gives suggestion to the Attorney General how the report must be there. If a scientist says it is 100% certain that this is the person who would have done, like what I showed to you about a case where a child, if there is a certainty that is a kind of 3 persons were already convicted, and then another person, when they were trying to find out, it was about a child, and that kind of certainty cannot be there. You should say the closest of what is seen, what would seem to be this person may be possible. There are errors which is in any one of these reports. There is also an error rate. What is the scope of that error? What is the percentage of error that is possible? All that will have to be appropriately represented. Because when we are talking about a scientific analysis and report, we are seeing from Section 45 of the Evidence Act, it says who is an expert. An expert must be a person who understands a particular branch of science, and his own association must be that he is competent to perform what he claims that he has done. So this is essential. If there is ever a trial to happen, or if there are papers which are seeing, find out whether there is appropriate evidence given there. As lawyers, we must see if a doctor says or a scientist says, I collected the sample is given, this is the seal sample which we opened from the police, we carried out the test, this is the report is marked as P10, and the court says P10, all the contents are there, therefore nothing is elicited. It's just hopeless evidence. The judge must ask, if there is a young judge there, he will ask everything of what is contained there in the report must be read in the court and must be made a part of evidence. That is when we will know what is it that the scientist has done, what is it that the doctor has done. Every doctor's report, you have now again in 291 and 93, there are two different things that CRPC uses. One is a scientific report, another is a doctor's report in 291, I think. So therefore, they employ different expressions, but as a generic expression, 293 will take in also the doctors. But then they need to state what is there in the report. It has to be elicited and brought out so that the judge understands what he has done. He has a scope for asking him, how did you do this? What was the analysis? What is the error rate which was possible? What is the degree of probability which you give? If you don't do and somebody says, now it's 100% is correct, this is what it is, then there is an issue. The cross-examination cannot also be, you are only talking about probability, doctor, therefore you are not certain. That is what is possible. Even in DNAs, we can only talk about a probability. And that probability, what is in the given situation, you'll have to see along with the other circumstantial evidence of what comes through and say whether that has been established. Merely take this scientific report and say it's all 100% true. It won't happen at all. That is a new legal perspective which we'll have to come to and understand. And that is why I thought it is essential for us to know that the British courts and American courts are guided by a scientific community which say now, even with reference to DNA analysis, there has to be a caution employed, and we'll have to say what is probably acceptable, to what extent it can be relied on. That is one thing which I wanted to say. There is another thing closely related to this DNA is the issue relating to the privacy. In the Puttaswamy, they said profiling of a person through his DNA it's exceedingly private. That privacy is now a right which is legitimately recognized as a constitutional right under Article 21. So it happens that somebody is picked up and taken to the police station. They take a saliva, they scrape it there from the skin, or they take saliva and then keep a DNA. They keep that to profile the person. So and take it in a. The person may not have even known. They would have collected that saliva, or some doctor must have come to scrape the skin and then take for DNA. But this was a point. This is again a recent case in 2019 where two persons who had been picked up and later let off after some time. They had they had taken samples for DNA. They came out, and when they were not charged, they filed an application to the court saying they asked the police to give back whatever the thing and not to destroy what they had collected. They were not prepared to do that, and they took it up to the matter went up to the European Commission, and the European Commission said that DNA profiling is a matter of personal record. It's such an important thing. It affects privacy. You can't take it unless he is a person who is required to give his evidence, because you have that again in the CRPC for any person who is suspected to have committed an offense. You can probably gather evidence, urine, blood samples, all that will be possible. It is available there, section 3A. But this has to be again seen only of persons who are suspected. And if the person does not go to the next stage, suspicion is not there, it is possible for him to even collect the application of law through what Puttaswamy brings to us. If a person is ultimately acquitted, or there is given a clean chit, it is possible for him to retrieve and seek for complete effacement of whatever evidence which they have gathered. It will be possible. Issue of legitimacy is an important thing, which you will see and recognize in our courts as well. Now it has also come to a stage where we say if DNA evidence is not collected, the Supreme Court has said in some cases that in this case DNA evidence is not collected, therefore it is not worthwhile. Investigation has not properly happened. The same way, even digital evidence, evidence of what is to be gathered there, cell phone, phone records, because even when I was a chairperson in the railway claims, I said, find out whether a person had cell phone, whether what is the tower, was he actually traveling or not. All that information must be available. Now the rules provide for that in the form itself. Was he carrying a cell phone? What is the tower which was registered just before his death? All that we see to ensure that we bring an identity. In a judgment in Tommaso Bruno versus State of UP, in a criminal appeal, the Supreme Court said like this: non-production of CCTV footage, non-collection of call records, and SIM details of mobile phones seized from the accused, they have all not been brought before us. Therefore, we don't think the prosecution can succeed. So therefore, offer important digital evidence of what they need to collect. You must be looking for all those kind of details, and if it is not produced, the Supreme Court says the best of evidence is not done. So therefore, in the forensic details of investigation, you expect, like I said, in DNA, all the digital evidence assumes a new significance which would require to be gathered and given, is what the Supreme Court says. In yet another case, again, this must have you must have known how the digital evidence is to be produced. What is the nature of proof which is to be rendered? This has come through an important judgment of the Supreme Court, where the former Chief Justice there, I think, was in the bench, and it was Justice Rohinton, Ravindra Bhatt, and Ramasubramanian. There is a judgment, an elaborate judgment by Justice Rohinton, and Ramasubramanian gives the second opinion, which is interesting in some sense for me, because it says how Section 65B, we were simply reproducing what was there in UK. When they made a change, we have not gone through a change. There is a deficiency in the way it is drafted. We may not be able to be, it is not as expansive as it should be. We still create some technical difficulties for production of digital evidence. We should ensure that we keep pace with technology, and the acceptability of certain types of evidence must be there by legislative change. This has come through a judgment in Pandit Rao versus Kailash. And this was a 2020, March, April, I think somewhere during the COVID time, it was the judgment pronounced. So these are aspects relating to some of this evidence of what you collect. There is one thing which has happened recently, not perhaps too recent, but it is from Chandigarh. It was some case which was before me at some point of time. I had therefore some interest to know what was happening. The constitutional duty, among other things, is to have a scientific temper. And scientific temper, just not the judges, the lawyers, the whole community must have. That is the constitutional duty now. In this case was a case of a person who the devotees claimed to be in a state of samadhi. When the matter came before me, I said, now the state of samadhi, where is the question? Two Apollo doctors have certified him to have died. You are keeping him in a freezer. Don't do that. Take it, but then bury and cremate it. That's what you should do. I was gathering that kind of evidence, but at the time it went off my hand. Later, Justice Bedi, MMS Bedi, was addressing that issue. That was a situation where the person claiming to be a son of that Swami, of that Baba, he arrived there. He staked his claim to the body, saying because that Baba left behind 1,000 crore worth of property. The case is probably disposed of by the division bench, and therefore making a reference. It's not a case pending. It has been disposed of, and therefore making an issue. I made an issue about it in the latest book of what I have compiled, and I've said when Justice Bedi said there is this is the person the doctors have certified him to have died, so therefore he must be cremated. The police must help. It should be cremated. Against this, the devotees preferred an appeal. Look at what has happened. Before the appellate, before the division bench, the argument was, we have faith, our religious faith dictates us to believe that he is in a state of samadhi and therefore we cannot burn him. See, it's perfectly possible for Lenin's body to be still retained, mummified, and retained there in USSR. They have some particular thing. Our religious or non-religious understanding is a person who is dead, and there are scientific methods of proving whether a person is dead or not. Even the Transplantation Act, the Human Transplantation of Organs and Tissues Act, also provides for the stem death, the brain stem which is dead. Is a person is deemed to have died, you can even harvest the organs and then transplant it elsewhere, is what is provided. Therefore, method of determining death is an important forensic exercise. A doctor must come and declare a person to be dead. How is it done? By looking at the body temperature, the onset of the stiffness of the body, or what we say. And there are several tools of examination. There are scientific tools of examination. Even the pupil, you would have noticed, if there had been a death in the family, the doctor first arrives and takes the pulse in his hand, or then opens the eye and then puts a torch there to find whether the pupil is there or has it become white. There are ever so many clear and scientific methods. But here is our division bench in Punjab and Haryana saying, people have faith that the man is alive. So therefore, we'll have to respect the belief. And Article 25 provides for that kind of a respect of belief. The division bench said something like this. They said, the belief of the followers cannot be forcibly shattered by the state or the court. Samadhi as a concept is not alien to the Indian society, having formed a part of many a folklore and mythology. It's all written in beautiful prose. It finds vociferous practitioners amongst yogis and ascetics. It is so this is what it said, and said this person is still alive. So I think this bizarre judgment must be set aside by the Supreme Court, or to allow for the continuance of a situation like this, that a religious belief will dictate whether a person could be treated as dead or alive. It's a dangerous precedent. So, but anyway, they brought a constitutional flavor to what was otherwise simple scientific yes or no situation. The question before the court could not have been. It framed the wrong issue, framed the wrong question. When the question was whether the body is to be cremated, because all legislation provide, all state, local bodies legislation provide for burning, cremating, or something. You can't keep it. There is a person, my mother died. I love my mother so much. I want to keep the body in my house all the time. I can't do. The corporation has a right to insist the body is removed because it has serious health hazards. You don't keep a dead body at home. It'll be teeming with so much of bacteria and dangerous stuff. So it's just not that. The life continuity, there's nothing more certain than death. That we cope with death, we take that into our consideration is what is important. The devotees there didn't have the courage to say the person is dead, he's in a state of samadhi, he can be kept there, he'll be keeping himself alive, he's not dead. But then they kept him in a freezer. They probably still have him in a freezer somewhere in Punjab. And a bizarre judgment which says it as a religious belief and therefore we'll have it. So therefore, look at issues in forensic science of death and birth and death. Death, when it takes place, is an important tool where there are clear matters of evidence as to how it is to be collected and how the scientific proof is rendered to that. One other aspect which has come to close attention through PCAST and other things, bite mark evidence. Do you remember in Mukesh versus Delhi, NCR Delhi, Mukesh and others, all persons have been hanged to death. It was the infamous Nirbhaya case. Among other evidence, I had the benefit of the entire evidence in my hand at the time when I was editing the book. And the prosecutor was good enough to share with me all the materials. And from Pune, there were odontology, the science of dentition, what the odontology of what they say, they'll be able to pick up information about the bite mark. See, sexual offense could be committed even without a bite mark in the way 376 has now been 375, the definition which has come. There may not be a penile penetration necessary at all. The absence of any violence is not an issue. The consent of how it was given, you will not presume consent merely because there was absence of injury. And these are things which have taken place by virtue of the report of Burma Commission. And important, what could not be achieved through a case in Sakshi the previous a couple of years earlier came through legislative changes. At the time, the union was resisting. It will be too dangerous to be thinking of non-penile penetration as rape. That can't be such a serious thing. But then this the change in law came through Nirbhaya. Unfortunately, we had a casualty through that bold woman, and we had a change in law. And there, the court found the so-called scientific reports of bite marks found there in the body to correspond to bite marks, the dentition of 2 or 3 of the accused persons. And the court said it's a scientific analysis which has been carried out, and it has been brought before us, and we fully accept. And this is perfect evidence which has been brought, and I think we should work. The Supreme Court said something like this: forensic odontology has established itself as an important and indispensable science in medico-legal matters, and expert evidence through various reports which have been utilized by the courts in the administration of justice. In the case in hand, the report is wholly credible because matching of bite marks with the tooth structure of the accused persons, and there is no reason to view the same with any suspicion. This is what the Supreme Court said. Completely unscientific, wholly flawed. All these lines must be taken as completely incorrect and unscientific, because it all happened sometime in the 80s in UK. Somebody picked up. I said, now the scientific validity must be there before we rely on something. The empirical study must show that a given mark will be identified as something which is characteristic of a particular individual. What happened was, it was seen in UK. Somebody merely announced that the bite mark have very typical situations. They are very individual characteristics they have, and the bite marks they found, it can be easily related to one person. Later, in 2-3 years, in 1987 itself, not now, 1987, somebody carried a case of 300 survey of 300 persons. The bite marks were all taken into some substance which could retain that mark and later examined. Out of 300 persons who were examined, 34 persons had similar bite marks, which meant fairly a very high percentage. We are talking about for 300, if there are some 35 persons, we are talking about 10%. They have similarity. If 300, if there was uniqueness, all of them must be independent. Each one, 300 must have 300 distinct marks. They were not so like that. So now this was taken later in a case, because this report came, they said the bite marks have no independent, there is no individual characteristic at all. It's completely flawed. Then it was a case where in USA, somebody, one Stephen Cheney, had been convicted. Then they brought this and they said that this bite mark is the only mark which is taken as the basis. This is not mine, because bite marks have various funny situations, and depends on because we are talking about even if it's a human tooth or not, that itself is difficult, is what the scientists say. The latest thing. Again, they say, notwithstanding the fact that it's as high as 10 to 20%, there could be similarity. They also found that the skin could be in a stage of violence. It could be stretched. It can be contracted. It is not an ideal situation where a person could have placed his teeth somewhere in some of the private parts or inside of the thigh or probably on the breast. All these things could be in a state of some kind of resistance or something. You can't get it correctly in an ideal situation. And some persons can have swelling in such ways that it is not even possible. The size or the impressions cannot be true, is what they said. So it came to such a stage where the Texas, in that the Court of Appeals, they said it's a junk law. There is nothing like that. Then there was the Innocent Project, was what the prosecution, several states they started. Wherever they found bite marks as the evidence, and a conviction rendered on that basis. They set aside all of them and they went on reversing judgments and granted acquittals. And that is now the stage. Now, in PCAST recommendation to the president, they've said bite mark evidence is such a hopeless evidence, it must be discarded wholly. So therefore, be aware if there is any such evidence which is brought in, you should be knowing that the whole scientific community is now rejecting the Supreme Court judgment in Mukesh, which it places this odontology as a science which has proven is completely wrong. It is not proven. On the other hand, the scientific community is rejected by bite marks as completely wholly irrelevant. So that is something which you'll know. But now recently I found in a 2020 article, there was some persons who have from this is one Kirti Garg, Rohan Sachdev, Gulma Singh. These are persons in 2000. They have given a scientific report in Indian Journal of Forensic Medicine and Toxicology, and they've said tongue has different, very peculiar characteristics. That I thought was extraordinarily surprising. While you find tooth, there is nothing. See, even in DNA, Siamese twins, the same sex twins, will have the same DNA structure. But even for twins, they say if it's tongue, it will not be the same. Tongues carry a distinct feature. Where will you have that kind of evidence? Where will you have the impression of tongue in any situation? Could be difficult. But then where you find whether a person's identity, if you are looking for a person's identity, whether that is a person, it's a human being, whether that is the person that died, from photographic images of tongue somewhere of a person speaking, then I'm saying something, how did I do? Or something like that, and a photograph is taken. You go close in on that, take those impressions, and then find out later with that person whether it is the same person or not. It is possible to say. That is what Kirti Garg and others they've said. The distinctiveness of the tongue print. There are no two tongues are the same, and the tongue of the identical twins are also not the same. The tongue provides both static and dynamic features for authentication, is what they say in a recent report. So that I thought was eminently surprising, something which we have not known. One more aspect which has come about is virtual postpartum. I'll be concluding now. Virtual postpartum is, again, you don't need to open the body. It's possible for you to have, it has been done in some place. The UK still carries out. That will be a matter of the future, where you don't rip the body at all. It will be possible for you to weigh the weight of every organ inside through a scan, and that can take place over a period of time. That could be one. I'll close with the one, two important things of what fascinated me. One was a COVID doctor, a person who was affected by COVID, and he died. His body was interned somewhere away because locally people were objecting. That was last year in May. So people had very serious apprehension. There were not too many deaths at the time, and when they were happening, people were scared where the body could be buried and things. Locally, the place where I live, that doctor happened to be living somewhere very close to my place, in less than 2 kilometers from my place. And the doctor's body was not allowed to be buried in the cemetery near his house. They took it far away out of the city, and the body was buried. The wife was terribly concerned. She was upset that even my husband's body cannot be buried here. She filed an application before the High Court, wanted the body to be exhumed and then brought back and interned again in the place where their family cemetery, where several of the family members had been interned. The court ordered exhumation and then directed it to be buried. They looked for no law anywhere across the world except in Ireland, where they permitted exhumation of the body to be possible for religious reasons also. So how is it important in a forensic study? We read the situation when a body can be exhumed. And we also see where there is a suspicion whether the person had been murdered or not could be a thing. Even without a murder, a person who had died due to an ailment could also be a circumstance for exhumation. This is the subject of an appeal before the bench. Bench has stayed it, but this is something which is new. And this is Anandi Simon was the party. This is state of Tamil Nadu. And there was one more case which was recent was a case of yeah, death of a person, and the use of the weapon was surprisingly a dessert spoon, very small. I'll show to you just this. I'll share with you the photograph. You have a look at this. You'll be astonished. And this has been brought in a magazine recently. Are you able to see that? Is the body? Are you able to see that picture? Yeah. So this is all. I'm showing to you the cursor, the yellow arrow. That is a small slit. That's all. There is no other injury in any part of the body. There was the spoon had been used, and the man died. Whether death can happen suddenly, the sudden death is an aspect of importance in forensic medicine. Could it result in death? This was a spoon cutting directly into the brain can cause instantaneous death, is what they said. No loss of big loss of blood. A small weapon, it just inserted above this, a small slit there, went over. The case reported from some place in North India. The case is still in progress. But death can suddenly ensue. So, in a subject of what can constitute sudden death, whether that should be a murder or unexpected, could it come under 304 Part A? These are all issues which can come later. But that there could be a sudden death in a situation by use of a spoon was what was brought out through this case. So my attempt has been, with that I'll conclude, to say what interests me now to what has happened in some branches, what books have brought about new studies, how do you assess probabilities in the manner when a report is made, how do you expect a scientist to come, required to come to court to say his own scientific knowledge. I said in DNA, or what is such a sure science, there are still issues of probability where you'll have to properly explain and then give is what the world opinion is. So I've also said about the digital evidence, the importance of what the courts are now looking. Look for, was it possible to photograph at the time? Was there the email, what was there? Was there a CCTV? All that are going to be important pieces of evidence which we would never have contemplated some time back, which would be all vital pieces of evidence now. What evidence is scientific is also essential for us to understand of so much of what the court says sometimes. I'm now standing outside the legal system. I'm not a sitting judge to be worried whether the judgment of the Supreme Court is correct or not. I'm now fiercely critical about things because I expect changes to happen, and so that the science and correct scientific facts are brought before court, so that the correct law is also set. So this has been my pleasure to present to you what I learned myself in the recent, after my last edition from 2017 to 2019, 2019 to 2021. What I've now recently seen is what I've given to you as fresh perspectives. Thank you very much for this opportunity to share my views. If there is any question which you would like to ask, I'm sure I'll be able to respond to the extent which is possible. Thank you.
Yeah. So you have taken to the entire new perspectives. Talking of that Ashutosh Maharaj judgment, thereafter, if you recollect, Justice Mahesh Grover and Justice Shekhar Dhawan had reversed that judgment of Justice MMS Bedi on Ashutosh Maharaj, where they said that it's a case of a personal religious belief. You can't say that you have to go for this. So meanwhile, one question has only come so far. That is by Ganesh Tiwari. I also watched it on the whether there is on something on the YouTube. So that's a quite long question. If you could just gaze through that, I think that will make more easy for you. Ganesh Tiwari.
Ganesh Tiwari says, if, for example, Mr. A make a mold of kind substance as ice mold, that icicle form, but in shape of knife, is stored water in it. Yeah, these are all things which we ask as puzzles. Some intellectual games we play where there is no evidence, nothing was there. The person made a knife out of ice, and then the substance was not there. A person can kill. So there was no proof available. Probably this is one of novels of I don't know whether it is as old as Prince or old novel. I'm not too sure whether this is an actual example. But what is the question? Let us go. Therefore, what is it? Therefore, if you stab B with that ice knife shape, it penetrates the stomach, but somehow it does not reach the inner part of the abdominal cavity of that person. But he got grievous hurt in stomach, and Mr. A left Mr. B in confinement with blood loss from stomach. So what happened later? As it
And
is,
now forensic and investigation team will find the evidence, as knife is of solid water form and it has now melted.
So what? Actually, ultimately, if you find, I told you, that's what probably I gave you a kitchen knife, not even a knife, a dessert spoon, the smallest spoon of all the spoons, makes a small slit and the person dies. So therefore, that there is not a weapon on which is available is not the thing. If there is any other evidence which is possible, where you can explain why is not the knife, where there is a knife, cut injury, incised injury, where is the material object which somebody is asking? The inability of the prosecution to produce the material object may not obtain any significance, or it can be scientifically explained. A person can make a knife out of ice which will melt, but which can still pierce and kill a person. So therefore, we'll be looking for kind of other evidence, and the forensic evidence will be a scientific evidence to say that there can be a sharp weapon like an ice can be made as a weapon to kill a person. Is what it is possible, is what will be the ultimate evidence, the scientific evidence which can place. So I don't see that as any major challenge. It's more a fun puzzle which is talked about in movies, in some of the books. That's how I see it.
I think it was a movie. I'm also recollecting. So one says, could you please explain the swab and smear test once again?
Explain what?
Swab and smear test once again on a brief note.
Yeah. See, we take a swab is when you have cotton and then it's a gauze piece which is taken on that, and then they press it against usually the most moist place apart from the tongue and the internal portion. They take it there in the cheek internally and then take a swab. The same way, there is a sexual offense committed, and where you try to examine whether there has been any penetration, whether there is any spermatozoa. The swabs are taken in a fashion which can absorb what is contained there, any fluid. When we talk about swabs, we talk about fluids or any substance which can be scraped and then put in a place. So therefore, normal method of gathering DNA is through application of instruments and imprint it on a swab, take it to a lab, and then examine it under a microscope or other gadgetry which will help enlarge things and identify, for instance, if it is saliva, if it is semen, what is the nature, what have we taken? Are we talking about a substance which is organic or inorganic? If it is organic, is it a body fluid, or could it be, is it sweat, or have we taken it from a door handle or something like that, where you still can take a print of how it is, how the impression is there by, say, sweat. Somebody could have, see, there are cases where there was a case in UK again. This was about a lady who had been raped and murdered, and they found a sample which coincided with a person who was living 200 kilometers away. He had not come to this place at all. So therefore, how did he? He was picked up ultimately, and they found alibi possible through some other source, and therefore he was acquitted. But they later found how it had happened, that in an accident which had taken place in his place, he had given his blood sample, and it was recorded, brought over to London later, and for examination it was cleaned, and then this examination was done for this lady, and that glass trace was still retaining the DNA. Now, we are taking about, when we're talking about the swabs, we take it in sterile conditions, ensure that there is a purity of the sample which we take. It is much better than what we take as traces. I said there could be several difficulties, even trace evidence of how certain types of extraction of DNA is possible. I said, therefore, there are several techniques of extraction, say various methods of extraction. And of that, depending on the quality of the sample, we'll be able to carry that particular method of DNA. So swab is that which you make possible an absorption of a sample and then use it in the lab. That is swab. You scrape, and what is the other one? What?
Smear test.
Huh?
Smear.
Smear again. See what is blood, for instance. When we talk about blood, we talk about the smear evidence. What you take blood, you must have seen there even in the labs, or what is one drop is let onto a small plate of glass, and then it is taken over another, and then they press it and then take it away. Then you have full of that. It's smeared all over the glass surface, and then examined under a magnifying glass, you'll be able to see what all it contains. The constituents of that will be examined. So therefore, these are methods of taking samples depending on the nature of fluid. A smear evidence of what you again semen smear. If also where there is an adequacy of the sample, where you need to scrape and take, where you are only looking for dried issues. See, hair, for instance, is an important carrier of DNA. Air, with that, if it is also some dried semen there, something like that, then you have a complex situation of the DNA of the air of the pubis to be seen attached to a semen which can be extracted and then seen. So these are to be again seen depending on the quantity, the quality of the sample which is available. They'll be able to extract it, take it as a smear, or keep it in a swab and then take it. So these are two different types of smear, swabs. There are two different types of extraction of the actual material for conducting your investigation. That's what it is.
Ravi says, kindly refer a book on forensic. So you can tell about your book on the forensics.
Yeah, I think there was there were two other persons with whom we were conducting a workshop for doctors in Delhi. The Delhi High Court carried that workshop for all the doctors in 9 districts. Somewhere close to in each, we had 6 workshops, and in each workshop they used to have, ideally we wanted not more than 25, but we used to have 50 or 60. So therefore we had occasion to meet with all of them. There was one thing which was stated there by, there were 2 other persons. Was one Jagdish Reddy, who is the principal of Vaidehi College of Forensic Science. Another was Padma Desali of CHAT from Bombay. So these were the 2 other persons. One is a scientist, another is a forensic expert, another me, a person trained in law. So we did that workshop, and she was saying, Dr.
So he's asking about the book which you have written.
That's what I'm saying. I'm saying, therefore, he was saying, if anything must change, if any law correct statement must be seen, people look to Modi's jurisprudence. So, sir, there are so many things which are flawed. So we were sitting and then examining every aspect, and I tried to update it with as much of science source as possible. So I have been fortunate to be associated with the book which has been worked by so many persons in the past before me, and I've been able to secure the best of assistance to make it fine. Only Chandigarh, you will find in the book which the last edition, the 25th edition, carries so many important facial reconstruction matters from Chandigarh labs. So therefore, I had the director of CFSL from Chandigarh giving me, and also the head of the department forensic science from PGMR. I had been associated with the 4 other doctors, and head of the department pathology from the government medical college there. So many doctors did the work. I had no source of gathering so much of information otherwise than through them. So there are a lot of materials given. If honestly, if you must ask what is the best book, there is no doubt that Modi's Jurisprudence is the best book on forensic science. I have no doubt about that. And there are exclusive materials on forensic science, not so much of law there, how to be conducting, what is the titration to be done, what fluid is to be seen, how is the sample to be taken. It's only for forensic, 100% forensic is Dr. Reddy. There is some book which he has written. Jagdish Reddy is his name. You can Google his name and find out the book which he has written. That is perhaps the best book on pure Jagdish Reddy. Dr. Jagdish Reddy.
Sandeep Vasudeva says, DNA tests are very sensitive. Our investigation teams are not knowing much about how to handle it. So what is your take to how
I want to say the same thing. I don't want people to, because the DNA is a perfect science, don't give simply blindly follow the reports. For there are bound to be variations, because they found as a measure of practice in about 100 doctors, if you're analysts, if you give to them, and there is something called as a cognitive bias. I didn't use this expression anywhere in my lecture, but I'm still telling you. If you want to bring a comparison, even for thumb impression is supposed to be 100% perfect science. But then if you pick up something, a trace from a thumb impression from a handle, and you want to prove whether it was a particular thief's thumb impression. I have, let us say, 5 suspects, and I bring the 5 suspects' thumb impression, and I gather something from the sample there, the suspected one, and then present it to an expert. There is a cognitive bias, they say. The bias is to find comparisons which are similar. Out of 5, the scientists will say, yes, one is similar. So therefore, there is a sure bias. The same way the kind of a bias can exist even in DNA samples. You will find similarities in some way, because in the STRs, when we're talking about the repeats, we go up to 15 or 16 or 23. We need to therefore ask the question, how many repeats were done? Was it sufficient? Was the sample adequate for you to bring comparisons? Is it sure that could be only this person? To the extent to which it is, that kind of an analysis would be essential. So therefore, you can't bring 100% certainty. It's a probability we are talking about, that there are errors which are possible, errors which can occur on account of the poor quality of the sample, the weather conditions, and several other things. But a cognitive bias of what the scientist has, you will try to support the prosecution to what he brings and says, this is the suspect we had, one of these 2 persons must have done. So please give us the report. The doctor will be looking, the scientist will be looking to find comparisons which are similar. So therefore, understand that there are a lot of fallibilities in the reports which are possible, and it is essential that we address ourselves. I showed to you those 2 texts only because the primer for judges is just in a small piece of 16 pages plus some 20 pages of annexures with graphs. Astonishingly vivid and lucid. And it is essentially for the judiciary, for the law. The same way the PCAST is, there are, for the report is to the judiciary. All the lawyer community must read and know what is the latest in the science in the matter of DNA. So that is my response to you.
Thank you, sir. In fact, Sandeep had asked it, but I had to push in somewhere. Already we are late. And the session was quite engaging, and we actually learned a lot. You have took us to the entire, I can say, the spectrum of law under the forensic and what actually have changed during this advent of time. So we are all grateful. And before we part for the day, what we normally say, keep maintaining the social distancing and get yourself vaccinated and remain at your home. That's the best way forward. And tomorrow we have a session on the employees' compensation, what is the procedure and practice with the latest Supreme Court judgments. Do join us at 6 p.m. And thank you, sir. We are enamored the way you have taken things forward. Thank you.
Thanks. Wonderful, Vikas, to be connected again to all of you. It's my proud privilege to be associated. I'm sure there'll be some.
We would keep on bothering you.